Kia ora koutou katoa. On behalf of the Board of Infrastructure New Zealand, I'd like to welcome you to this panel discussion on resource management system reform facilitated by Daniel Minhinnick from Russell McVeagh. Before I introduce you to Daniel, just a reminder to use the live Q&A function, which will be available throughout the session, or the discussion forum is also available for you to leave comments during the session as well. So our facilitator for today's panel discussion is Daniel Minhinnick. Daniel is a partner and the National Practice Group Chair for Environmental, Planning and Natural Resources at Russell McVeagh. Daniel specialises in resource management and environmental litigation and in providing advice to major development projects. He has appeared before all levels of the New Zealand court system and advises on a variety of projects including residential, retail, commercial and industrial, energy and infrastructure projects, mining and hazardous waste facilities. Daniel also offers advice on district and regional planning matters, legislative reform, local government matters, and Public Works Act issues. I'll now hand you over to Daniel to introduce you to the other panelists. Thanks, Daniel.
Thanks, Katrina, for that kind introduction. Kia ora koutou katoa. Russell McVeagh is delighted to be a sponsor of this year's conference, and it's my very great pleasure to be able to facilitate this panel on resource management system reform. You may notice that I have a bit of a lockdown hairdo. I think many across the country, particularly in Auckland, do have that at the moment. It is a product at the moment of my wife not being prepared to touch it, having already had a pretty average effort at trimming our toddler's fringe. And as much as my 4-year-old would love to have a go, there's no way I'm letting her near it. Now, the conference's theme, A Fork in the Road, really resonates for me, but it is particularly apt when we're talking about the current state of the resource management system and what it means for infrastructure. The failings of the current system are well known and are keenly felt. We're facing ongoing environmental degradation and a failure of the Resource Management Act to protect those parts of the natural environment that matter most. We've lost over 90% of our natural wetlands. Our freshwater quality continues to deteriorate. Biodiversity is diminishing, and we face an urgent need to reduce our carbon emissions and to adapt to climate change. However, at the same time, our urban areas are literally bursting at the seams, and we're struggling to keep up with population growth in some of our largest urban areas. But that's enough doom and gloom for now, because there is some positive news. The independent review panel that carried out a comprehensive review of the resource management system was clear that the RMA is no longer fit for purpose and change is required. A new system has been proposed and the government has taken on the panel's recommendations. The proposal is essentially to repeal the RMA and replace it with 3 new pieces of legislation. So I'll bring up now a diagram prepared by McVeagh that does show that new system. So I'll briefly talk about some of the key features. So the first new act is the Natural and Built Environments Act, which you'll see in the top left-hand corner there. While perhaps seeking to ride the coattails of the last dance with its acronym, the NBA is essentially RMA version 2.0. All of the plan making and consenting processes we've come to know and love will be incorporated within it. Key features proposed include the incorporation of strict environmental limits and a focus on the new concept of te oranga or te taiao, a move away from focusing on the management of effects to a new framework based on the promotion of positive environmental outcomes, a strengthened role for Māori within the resource management system, a greater role for central direction with a mandatory national planning framework to be established to achieve greater consistency across New Zealand. And then on the planning front, the consolidation of plan making, moving from over 100 different regional policy statements and plans across New Zealand to 14 combined planning documents. The second piece in the puzzle is the Strategic Planning Act. That act brings statutory weight to spatial planning. The integration of infrastructure planning, funding and delivery with land use planning has largely been a myth, and the Strategic Planning Act sets out to change that. It also drives towards greater integration and coordination of central and local government and iwi. And then the third piece of the puzzle is the Climate Adaptation Act. That act will address the gnarly topic of managed retreat and the complex issues of planning, compensation, and insurance that surround it. So as you'll see from the image, the system is complex. However, the issues that this system needs to grapple with are even more complex. Bringing all of this new system together, particularly in a single parliamentary term, is no mean feat. The process is well underway. In fact, we're in the midst of a unique legislative process with the release earlier this year of an exposure draft of core elements of the NBA, allowing public input into some of its key features. And I'll return to some of those key features shortly with the panel. Infrastructure sits at a fork in the road of risk and opportunity. The reform process offers real opportunity for the infrastructure sector, and I'll run through 5 reasons that the sector has to be optimistic. The first one is spatial planning. One of the game changers in the panel's recommendations was the elevation of spatial planning. The disconnect between infrastructure planning, funding and delivery, and land use planning has been a key contributor to many of the significant issues faced by the infrastructure sector. Various attempts to bring them together previously has failed. The panel's proposal to create a new overarching act that brings central and local government together with iwi to develop those spatial strategies with input from infrastructure providers has the potential to offer huge opportunity for the sector, particularly in terms of identifying and future-proofing key infrastructure corridors and better aligning infrastructure planning with the Local Government Act funding decisions. The second reason is a possible end to NIMBYism, or perhaps more likely a significant curtailing of the impact of NIMBYism on project consenting. One of the ways that infrastructure projects can be held up is local opposition, whether it be because a cycle path is viewed as being catastrophic for the leafy suburb at one of its landing points, or whether a stormwater pipe is better designed by a group of local residents than experienced engineers. The views of local residents can end up delaying major projects at significant cost. A conscious move away from the maintenance of amenity values within the NBA offers hope that some of those days may well be behind us. And while local views are critically important as well, it does seem that recalibration is required, and this change will be significant. The third reason for optimism is outcomes, outcomes, outcomes. One of the slightly depressing aspects of preparing a resource consent application for a major project is that you often spend only a few paragraphs addressing the positive benefits of the project compared to dozens of pages addressing all of the potential adverse effects. This focus on the management of effects is central to the RMA. However, the paradigm shift to a focus on how a project promotes a range of positive outcomes offers the chance for planners to get out of the weeds and take a bigger picture view. The fourth reason for optimism is streamlined planning processes, consenting processes. A significant source of grief for consent applicants are the delays and red tape inherent with the current consenting system. Streamlining that process is an important goal of the new system, which will be welcomed by the infrastructure sector and other applicants. And then finally, the fifth reason is the end of Frankenstein's monster. So finally, perhaps the biggest opportunity with the new system is that it offers a fresh start. The endless tinkering with and adding sections onto the RMA has not worked, in part because of the baggage the RMA carries with it has simply become too great. Starting with a fresh page offers the opportunity for a big step to be taken towards the broader cultural changes required. There are risks, though, too, for infrastructure with the reform process. I'll briefly touch on 3 of them. The first is whether strict environmental limits will end up preventing or hindering the delivery of the infrastructure we need as a society. And I'll certainly explore this further with the panel, particularly in light of the recent experiences with the National Policy Statement on Freshwater Management. The second is whether the multitude of environmental outcomes that are all sought to be achieved at the same time will lead to over-promising and under-delivering on those outcomes, particularly in relation to infrastructure. And then the third risk is in relation to transition. The scale of the reform process does not stop when the legislation comes into force in the next 18 months or so. In fact, the roller coaster ride will have only just begun. Developing the national planning framework and regional spatial strategies are complex processes that don't happen overnight. And then there are the combined plans themselves. Anyone who survived the Auckland Unitary Plan's development will understand how intensive the development of a combined planning document is. We'll all have that to work through 14 times over. And while there'll no doubt be efficiencies through the process, the scale of that task cannot be underestimated. Overall, we're all looking at a decade ahead of transition. So, having just scratched the surface of the myriad issues that RMA reform generates, it's time that I introduced our fantastic panel so that we can hear their views and get into some debate. And I certainly encourage those of you viewing to put in your questions. We do want this to be an interactive panel. So our first panelist is Matt Paterson. Matt's currently the Chief Advisor, Policy and Programs to the Parliamentary Commissioner for the Environment, the Right Honourable Simon Upton. In that role, Matt coordinates and provides policy input into the Commissioner's extensive work programme, which aims to maintain or improve the quality of New Zealand's environment. Matt has over 20 years of public policy experience working in and around government. He was the Stakeholder and Policy Director for Crown Research Institute Scion, and prior to that, Head of Advocacy for Property Council New Zealand. And he's also worked for the Ministry for the Environment, the Minister for Climate Change Issues, and the Ministry of Foreign Affairs and Trade in various roles. Next up is Al Cross. Al is currently the General Manager, Environment Management at Greater Wellington Regional Council. He has oversight of the Council's environmental and resource management policy setting, science monitoring and investigations, regulatory implementation, as well as the region's regional parks and forest network and harbour navigation and safety management. Prior to this, he managed the Council's Environmental Regulation Department, looking after the region's consent processes, compliance, enforcement, environmental incident response service, and business pollution prevention functions. Al has managed relationships and processes for some of the region's most significant infrastructure developments, including major state highway constructions, the development of Wellington's waterfront, wind farm development, and water supply. And so he'll be able to provide some unique insights from a council perspective. And then third, we have Amelia Linzey. Amelia is a planner with over 20 years experience in the field. Her extensive knowledge and leadership in the space saw her invited to join the independent panel for the comprehensive review of the resource management system in 2019 that I spoke of earlier. Amelia is a Senior Technical Director at Beca, a member of Beca Group Board and the board sponsor for sustainability. She's directed many community-changing strategic and policy planning, infrastructure planning, statutory consents and consultation projects. She's passionate about the growth and development of communities and places, and particularly enjoys working with communities in collaborative problem solving. She's worked with a diverse range of clients, including infrastructure clients, to deliver transformative change through projects across New Zealand. She's been a member of the advisory board for the New Zealand Sustainable Business Council and is an alumni of the Global Women Breakthrough Leadership Program. So with that panel we have before us, what I will do firstly is ask each of them to briefly discuss what they see as some of the most important aspects of the reform process for them. And so with that, Matt, would you like to start speaking of some of the key aspects from your perspective?
Sure. Kia ora koutou katoa, ko Matt Paterson aho. I want to actually start by stating the obvious. I'm not Simon Upton. Many of you, or some of you may be too young to remember that he was the Minister for the Environment when the RMA was passed. He's now the Parliamentary Commissioner for the Environment and has a statutory responsibility to speak up on environmental issues. And RMA reform is one of those issues. While I work with Simon and we jointly discuss the RMA quite a lot, and our views are very similar on that, the views I'm going to express today are mine and not his necessarily. With that partial disclaimer in mind, I have two key points that I want to frame my participation on this panel with. First is the critical importance of environmental limits. And the second is asking the question, what will the Spatial Planning Act actually do? Or probably more importantly, what more could it do? On environmental limits, the original intent of the RMA was to have development within environmental bottom lines. But for a whole number of reasons, the practice didn't live up to that ideal. There was a King Salmon court case that actually rejected the idea of overall balancing and reinforced that some degree of bottom lines meant to be there in planning practice, despite the jurisprudence that created. Decades of planning practice couldn't really quite get that. So as a key part of this reform is to properly codify environmental limits into the structure. And I think that's a really good addition and actually one of the most critical things that the reform does. My perspective is that the environment has to take primacy in any planning system. That means environmental limits have a lot of work to do. They're going to have to be ambitious, they're going to have to be meaningful, and more importantly, they're going to have to be robust. This doesn't actually mean environment at all costs. What it means is the integrity of the environment needs to be considered and protected, and development occurring within those boundaries. It's not anti-development, it's rather development within clearly defined boundaries. What worried me a lot about the submissions on the exposure draft that the Select Committee just heard was there were a lot of calls, including from many infrastructure providers, for exceptions to environmental limits already before we even have them. Exceptions, at least very broad ones, to me are in a way a lazy way of saying we don't want to do the hard work to find a solution that is going to work for both the environment and for development. Those solutions exist, we just have to find them. There's an even bigger risk that having an exception for one sector will call for all sectors to have exceptions. And we've already seen that in the Wetlands National Policy Statement. That would make environmental limits essentially meaningless. Now to spatial planning. I don't have a crystal ball, and it's very hard to say anything concrete because the government hasn't given us a draft of that act in the same way that it has of the Natural and Built Environment Act. What I have seen so far, my key question is going to be, is that act actually going to do enough? Or framed another way, is what the Natural and Built Environment Act, with environmental limits and outcomes and national planning frameworks and a whole bunch of process, is it actually trying to do too much? Can we share the weight and get the Spatial Planning Act to do a lot more heavy lifting? One of the key criticisms of the NBA exposure draft was it didn't actually do enough for development and infrastructure and the built environment more generally. There were also contradictory complaints of there are far too many outcomes, how are you going to resolve them all? Yet there still were not enough outcomes to deal with all the issues. Maybe actually dividing which outcomes get dealt with under which act might be a better way to manage them. I think, for example, spatial planning is going to be really good for infrastructure. And Daniel identified it as one of the really key opportunities. I think it was first on his list or second on his list, maybe. And infrastructure and the built environment are clearly quite connected. Most things about the built environment are also spatial by nature. So could all of the proposed outcomes around urban development and infrastructure be done more in the Spatial Planning Act than the Natural and Built Environment Act? I'm conscious that this idea is running dangerously close to the line, in fact, has probably already crossed the line of what is the now sacrosanct environment and development need to be integrated. That integration was actually the intent of the original RMA, but it hasn't worked for 30 years, and we're still going to be sticking to that nirvana now. I asked myself, actually, maybe what we're trying to integrate are the wrong things. While I was at Property Council, and Daniel touched on this as well, one of the key issues was the lack of integration between built environment planning, infrastructure planning, and central and local government funding. The Natural and Built Environment Act, as proposed, won't integrate that funding issue. There's an idea that it's going to be done in the Spatial Planning Act, but we haven't seen a draft for that. But for that integration of funding and outcomes and built environment to really work, I think the Spatial Planning Act has to do more on those built environment outcomes. That's where we're going to get some real gains if those things are integrated. That would actually then allow the Natural and Built Environment Act to focus a bit more on protecting the environment. Now, I realize that's a potentially controversial point, so I'm going to leave that there. And I'm also very interested in hearing what the other panelists might have to say on these issues, because they come from quite different perspectives. Thank you.
Excellent. Thanks, Matt. And I think already a number of points in there that are stirring up a number of questions online. So over to you, Al. Are you able to speak to some of the key points from your perspective?
Yes, I can, Daniel. Thank you. Ngā mihi o te wā, kia tātou, tēnā rā koutou katoa, ko au cross toko ingoa, he kai whakahare, mātua taiao, General Manager, Greater Wellington Regional Council Environment Management. And it's a really real pleasure to be here with the fellow panelists and speaking to you all today. I want to touch on several areas, and I'll also draw from a recent speech by Minister Parker to the LGNZ Zone 4 meeting late last week, a couple of tidbits, and also the report back from the Select Committee. The areas I'd like to touch on are around national direction alignment, the packaging of the bills and opportunities there that may or may not be taken, particular issue around strain on mana whenua participation and their ability to participate. A little bit on limits, but mainly behaviour change, system change, and in that respect, then opportunities and risks for the infrastructure sector. So, just briefly on national direction alignment, we all suffer from the fact that we don't appear to have an alignment at the upper level in terms of policy settings. We don't have that single crown voice that draws together the key policy platforms and enables them to be integrated for delivery and outcomes in an appropriate way. So we find ourselves battling this, and sometimes battling each other, trying to make sense of policy priorities. So that is critical going ahead into this round of reforms in the development of the bills. That whole system approach also needs to be able to pull together the information systems and evaluation into an integrated package, but particularly set around integrated policy setting. And I'd like to say that alignment with the review of local government would be ideal, but is not a reality. The integration of the bills themselves. So obviously we're talking about 3 tranches, but ideally it would be most useful if we could integrate at least the MBEA and the Strategic Planning Act into one package, so that we could enable the architecture to be teased out, the moving parts to be worked on, so that they could actually work together more elegantly, and also enable that package to be delivered together. So we've already heard some comments about that lack of integration, so we do need that. And I would note in hearing from Minister Parker that he expects spatial plans to drive funding, particularly in relation to big items such as infrastructure. And in that sense, then the funding decisions would need to go hand in hand with spatial planning. I'll touch on mana whenua participation. I think we all again suffer from our inability to be able to bring mana whenua to the table, because typically across the motu they are under-resourced and have a whole range of priorities that they must deal to within their respective rohi, well beyond the resource management system. And look, if the bills are to deliver on the potential outcomes, we need to be able to find a way of bringing mana whenua to the table, and that may be by way of appropriate funding mechanisms to enable them to participate, to be able to buy in expertise, but it is fair to say there are capacity and capability constraints throughout. Also, the opportunity to build capability and capacity through training as well might be an option. And on the notion of mana whenua participation, I would stress that the inclusion of Te Mana o Te Wai in a more central sense to the purpose of the MBEA bill would be a great gain. I won't actually touch on environmental limits. So Matt went there, and I won't touch on that. I do have a view on that, but I will talk about behaviour change. I think there's a tremendous opportunity for behaviour change within the system. I don't actually think that the promise of the outcomes that Daniel touched on can be enabled in their full unless we have overarching behaviour change in the system. So what I mean by that, I'm meaning we all have to collectively lift our game to work more collaboratively together. We have to be more sophisticated in our thinking around how we develop systems for the management of particularly infrastructure projects and programs that bring together the respective parties and partners that identify and respect the respective roles. They provide structure, process, and transparency, but also mandate the solving of problems that can't be solved by one respective party or another by their own. So I think that system change and lift and behaviour change presents a tremendous potential, irrespective of any system change. Finally, look, I'll just touch on some opportunities and risks in relation to infrastructure. So I think in terms of opportunities, the infrastructure sector has a great opportunity to really lead the way in bringing balanced solutions to the reforms table and driving particular elements of that agenda. There's huge insight, experience, and pragmatism within the sector to be able to bring to the table. So if that's done in a particularly balanced way, I think that could be quite successful. I believe there is a place for fast-track consenting within these processes, and if we can pull out the great learnings from the current fast-track consenting system and processes, then I think, again, that would be a great option for us to be able to use into the future. I see the infrastructure sector's role in full participation in regional spatial planning as a huge opportunity. And really, in terms of regional spatial planning, that is the golden egg in terms of lifting those resource management and environmental management system outcomes. Again, building relationships and leading the way on systems thinking, you can do that. You can do that well. And I think there's a good argument for preferential consideration of infrastructure developments through the regional spatial planning process. So I will leave it at that. Thank you.
Thanks, Al. Some really interesting insights, and I think particularly some of those comments around the behaviour change and cultural change required. That's certainly a topic that a number of viewers online are seizing on as well. So we'll return to that shortly. But before we do, Amelia, do you just want to speak to some of your key thoughts? I guess, having been involved in the reform panel itself, you've got a huge amount of as far as your insights into it, but just sort of drawing on some of the key points from your perspective.
Kia ora koutou katoa. Kia koutou tēnei te mihi mai aha ia koutou. E hore aho e te Māori, e ngara no Aotearoa, no Waikato, rātou na Tamaki Makaurau, no Otipoti, no Taitoku aku tūpuna. Kei pukakoe te kāinga e nainai. So I like Daniel also suffering from the lack of haircut and the working from the back office. No Melbourne ahi te rairea o ko Amelia, Linzey, taku ingoa. No reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Look, it's going to be a little bit tricky. I've got a few points I want to make, and obviously maybe a little bit of rebuttal to reply to a couple of Matt's suggestions as well as I go through this, just to sort of generate a bit of a discussion. I did want to highlight a couple of things that I think are really key, and a number of them we've already all touched on, and I'll just try and bring out a few things that I think are really critical, in my view, to why the change in the system is of benefit to sort of society at large, to the environment, and particularly to infrastructure in the context of the conversation. I think the relationship between the Strategic Planning Act and the National Planning Framework, and then into the NBA, is a really massive opportunity, and we've talked to that quite a lot. To me, the big shift is the shift to outcomes, and the role that the spatial planning process will have. And I do agree with Matt about the relationship that Spatial Planning Act will have in setting or helping shape up the intent of those outcomes in a spatial representation. The thing I don't agree with is I don't think the separation of protection functions and development functions is going to achieve is going to improve our situation. And while I acknowledge, and in the Randerson report we came to the conclusion that the efforts of integrated planning for the last 30 years haven't delivered all the outcomes that we were looking for. At the same time, it's a difficult counterfactual. And when you look overseas, I think not trying to integrate them, it isn't a Protection Act process, it is a resource management system process. And I think the imperative on us and the pressure on us is to integrate. I think that's harder, but I think it's a challenge worth taking on. And part of the reason I think that it goes to that outcomes drive. So one of the big challenges we've faced with our system to date has been essentially what has been couched as the status quo bias, but I think is a presumption, and this is a massive presumption in our infrastructure consenting process, that the status quo is the alternate to consenting something is not to do something. And I think as we move into climate adaptation and resilience requirements, and as we move into emissions reductions plans becoming part of our lexicon in terms of the direction we need to sit, and in response to the climate decarbonisation objectives, and even as Minister Robertson and Ian referred to yesterday, the intent of infrastructure to support economic recovery, these are forward-looking processes, and I think it is time for the system to look to those forward outcomes that we are trying to drive to, and make decisions on the contribution that resource use and resource management is giving us towards those outcomes, rather than from a backdrop of the alternate being to do nothing and the environment staying as it is the suitable alternative. And I think that that's true of infrastructure, but I also think it's true of environmental outcomes. As we look at climate change and adaptation, we're going to need to start thinking about how our ecological systems are going to have to adapt and change to be resilient to the climate change that we've already banked, that we've failed to reverse. And so I think that forward-looking presumption, again, I think it's more complex, but I think it's a necessary step to achieve some of the aspirations that we've had in our resource management systems. And I think the Spatial Planning Act provides a big platform and opportunity to do that. I think the second one I just wanted to touch on with that is the opportunity it creates for placemaking. And again, I think we sometimes overlook the role of infrastructure in building communities and in shaping communities. And I don't think that that means that infrastructure has primacy. I know I do, and we talk a little bit about that, and I think that comes up when we talk about should infrastructure have some exemptions to limits, and I do have some very similar hesitancies to Matt and Al in that regard. But I do think we need to consider the role that infrastructure has in contributing to placemaking and in contributing to many of the environmental outcomes. I mean, that is the thing that drives a lot of our system design in terms of infrastructure, some of the green outcomes of them. So that's probably my sort of sales pitch or capture of the spatial planning provision. I did want to just touch a little bit on the importance to me of the role of targets in complement to limits. And I think this is, again, perhaps one of the areas where, as we are working through the exposure draft and as we are understandably, but maybe regrettably, seeing a sort of incremental additions of what the MBA will look like, and without the context of the spatial plan, the Strategic Planning Act to refer to that, I think we are thinking very much of limits in the context of consenting applications and how they will apply. And in my mind, as we were working through the Randerson report, and this does go to Al's comments on, on the extent of culture change, the intent of the Randerson recommendations in that report was to shift a lot of our energy and focus in planning and in the resource management system to plan making. And that goes to the limits as well. So I think the relationship of limits being the controls and minimum standards of which we think irreversible environmental harm will occur was to set that and then set a target of the aspiration of where we wanted outcomes to get within a time frame in plan making processes, not solely in consenting. And I think we have turned very quickly to thinking about how limits will be applied in a passing or failing of a specific development proposal, where the intent and focus of a lot of our thinking was how limits and outcomes would apply in plan making. And that is reflected, perhaps a more a cogent example I can think of is we talk about the complexity and plethora of the outcomes in the Spatial Planning Act, and I think, in the MBA, and I think that again, if you think about that at the time of every individual consent and apply them then absolutely I can understand how that complexity arises. If you're thinking about how outcomes and the different priorities for outcomes will relate as you're going through a plan making process, and you're looking at how you're going to use resources and allocate resources across a plan, and how you might prioritize some outcomes in certain areas and other outcomes in other areas in the overall objective of achieving the purpose and intent of the plan, then I think you get a different picture of the complexity of outcomes, and it is driving much more to a number of the points that Al was referring to about that need for collaboration and integration. But at that plan making stage, again, completely agree that the intent was that once that has been done, and I wouldn't underestimate the scale of resource, and you, Daniel, again very rightly referred to things like the unitary plan process and the pressure that created, but I haven't heard anybody from the unitary plan process yet say, but I'd rather go back to what we had before. And even that step change of integration that required, I think, has put us in a better place in the Auckland context, and I think the MBA provides an opportunity for us to take that forward another step and in another level of sophistication. And then the fast tracking and streamlined consenting processes that we've referred to and that you referred to as an opportunity for infrastructure, I think start to make a lot more become a much more credible story because of the emphasis that has gone into getting the puzzle to fit together at the time of plan making. So I think that was the second point, and that's why I think targets in terms of those interim drivers of where we're heading in plan making will be critically important. And then the final thing I wanted to talk about was the cultural change in the system. And again, a lot of this does replicate the comments that Al made, but I did want to sort of perhaps raise a bit of a call to arms of the importance of the transition of getting this right. I think one of the challenges we reflected on a lot with why or what hadn't why the RMA hadn't achieved what it intended to achieve was perhaps a reflection on the amount of the rate and pace of implementation and the resources that were put to it meant a lot of plans just become a transfer from the old Town and Country Planning Act into the Resource Management Act. And we were constantly then working on how do we adapt the system back to what we meant by the RMA, and then we had 31 amendments to the RMA to try and patch that gap as we went on. And I think that has been a large factor in why we look back now with the sort of benefit of hindsight and say that act didn't work. I think the transition for the implementation of that act kind of put it on the back foot from the start, and perhaps we never overcame that. And I think it's incumbent on us to think about the transition and what might be a reasonable rate and pace of change, and how we perhaps can incrementally introduce elements of the Strategic Planning Act and spatial plans and strategies that come from it, and the steps that we might be able to take. And I've got some thoughts on that transition, but I think that the culture change is very large in terms of plan making, and the transition as we move from an old system to a new system warrants a little bit more consideration. So they were perhaps some of the three highlights that I would have picked up in terms of the conversation that we've had around the table. Thank you, Daniel.
Great. Thanks, Amelia. And so the questions are pouring in from those online. Do encourage those online to give the thumbs up to those questions that you do want asked of the panel. I guess first one from me, there's been a lot of talk from particularly Matt and Amelia, both of you, regarding the approach of environmental limits and outcomes. And we've had the recent experience of what seems to generally be considered as an unsuccessful approach to the use of limits within the freshwater management NPS, with the carve out initially for infrastructure, now discussion on a broader one for urban development. And I guess a question as to what has gone wrong with that process. Is it that the limits weren't set correctly to start with? Is it that it's lacking that outcomes dimension to it? Or is there something else that's causing those challenges that are being faced by everyone through that process? Perhaps, Al, do you want to start?
Sure. Thanks, Daniel. I actually think that process, certainly in my experience, has been relatively successful under the NPS for fresh water. And the reason why is that certainly in our region, and other regions are replicating as well, is the basis of the process around a committee of the community and mana whenua to then develop the values that will then apply to the development of targets and limits within catchments. And now the process that we are then going through to uplift that mahi out of our whaitua implementation programs now into a series of plan changes. So certainly I would acknowledge that across the motu that hasn't been successful. Perhaps it's been a bit mixed. Our experience is a different one. So I feel as though the framework is there. It's the way, again, that you actually form the system of developing your limits and targets and then uplifting them. And again, it comes back to the points we've been making around the culture lift, the culture change, the development of the system, and the behaviour change to enable that to be successful. We're a long way from getting these through our plan changes, but every indication so far is that we're well on track. So I'm probably not the best person to talk about there being a problem with that system. I think there's tremendous potential and opportunity with the development of limits within the NBEA to be able to lean on some of that experience, positive experience across the motu.
Sure. And I guess looking more at the wetlands issues under the NES as well. Amelia, your thoughts on how that has played out and what lessons could be learned for the identification of limits moving forward?
So I think there are a couple that I would reflect on, and it probably is more centered around some of the wetland issue that we have seen, and that really has gone to the clarity of definition and interpretation, and for hard limits, hard science, and I think this is one of the challenges I think we do have with limits. It does drive us very much to a conversation, again, that we have had a lot in the RMA, and I don't know that it has served us that well, about how broken something has to be broken, and how bad it has to be before we've hit the sort of the line of no return, and we end up from a scientific point of view, that line is often very hard to identify. We challenge ourselves. We have identified, perhaps in the case of the wetland example, we have been somewhat, well, the interpretation has been that the intent of that wetland definition was much wider than perhaps people thought at the beginning. So we've ended up with a bit of a difference between what people thought they were setting a limit for and the interpretation and where that has fallen in terms of what we think that limit will look like. So I think that's a clarity in definition, but I also think it drives us very much to debating when we've crossed lines and exactly where those lines are. And the problem there is dynamic environmental systems make that an incredibly intensive thing to set. It is, again, my mind, one of the challenges that that we have with constantly looking at an effects system that says what are the negative effects we can live with, how bad can they be, and where is the point of no return. And we've discovered those points of no return, sadly, in most cases, because we've crossed them and we've gone, it was back there. And that seems to have been the most effective limits that we've known about. So I think it is putting a huge amount of energy into the system, particularly if you're focusing on what those limits will need to look like as resource consent controls rather than as planned development and resource allocation controls, where I think it is a more appropriate discussion to be talking about limits in that frame. So that's probably my thought on that one.
Thanks for that. One of the most popular question online is stepping back and asking the question, is it fair to really blame the legislation, or should a lot more blame be targeted at councils who failed to use the tools that are already available under the RMA? I know that Simon Upton has commented on some of these issues previously. Matt, do you want to start on that?
It's definitely not fair, I think, to blame the legislation. I mean, it had all the right elements, but equally, I don't think it's necessarily fair to blame councils, because actually we're realising there's some new tools and other things that will help. And I think spatial planning is one of those tools. And just to go back to the last discussion about the MPS on wetlands, I mean, wetlands themselves are probably one of the more complex ecosystems that you're ever going to try and have to set limits for, because it's not just biodiversity, it's about water quality, it's climate mitigation, it does flood protection. They're place specific in their own right. If we'd had spatial planning when we were trying to do that stuff, it would have started to identify that conflict really early on and have that conversation between the infrastructure providers and the councils and to work that out. We're also very new in setting environmental limits. We're trying to work out what they are. They're meant to be biophysical rather than just spatial no-go areas. Now, those are all tools that we have now learnt would be very helpful. In many cases, there's no reason you can't do those under the RMA, but just the practice of both councils and the other players in the system, whether they be the local residents in the communities, whether it be the environmental NGOs or the developers, have led us down a particular path. And one of you made the point, actually, this is just that opportunity for a bit of a reset. That the mechanisms worked well, but this is an opportunity for a reset for those to just get away and have that culture change. And I fully agree with what Amelia was saying. The RMA was meant to be that culture change, but actually that lack of transition meant we just picked up a lot of the old bad habits as well, and we never spent the time getting those good habits on. And unfortunately, we're going to have to probably do the same thing with the RMA. The thing we need to be careful about is that we don't just grab any new system because it's better than the old system. Or because we think it'll be better than the old system.
And Al, I'm sure you've got a view on this. And I guess you've talked earlier about the need for behaviour change by everyone. And I guess the question for you, just building on that, is the legislative framework enough to drive that behaviour change, or is there also a critical resourcing issue that needs to be dealt with? And you've addressed it in terms of iwi, but for local government as well, in terms of making sure that local government has the capability and capacity to deliver on the change that is contemplated, both structurally as well as behaviourally.
Yeah, thanks, Daniel. Look, the obvious is that there is a resourcing issue and conundrum there if we're to meet the potential that these reforms offer. So that's an ongoing work on, and I think that conundrum is just one of the expected necessities of change. We do need to be mindful of it. I think the legislation provides that call to arms around integration, the strength of the spatial planning process to be able to deliver that. And that call to arms, as I come back to again, is looking at the system, looking at the way we work together in a more sophisticated fashion. Having worked in the council space and worked together with other regional councils and our territorial authority partners, I see that we need to have a maturing of the role of the regulator in this as well, which is not to say that the regulator actually kind of sits over there in a bubble, but is to say that the regulator has a role, but that role is one whereby there is a bespoke process and series of processes that are theirs to run and determine, but also their role is part of a system. And I think we do in local government lack that maturity to come together in that whole system approach. So again, I'll just put that back on the table. I think there's so much opportunity in that space.
Excellent. Now we are quickly running out of time. Another question that's come up, and one for Amelia, one of the key aims of the reforms are to reduce complexity and increase efficiencies. Do you think that the proposals and where things are heading, having seen the exposure draft, are heading in the right direction on that front?
I think the idea of the national planning framework, so when we talk to the recommendations, and I think this actually, just because you want to add it, you want to chip a bit in, I think the other player that perhaps didn't step up, if we're looking at a little bit of a retrospect and we talk about councils, I think the role of central government and national policy statement and direction is a foregone criticism of the system, and I think it's unfair to ask someone in that system to make that comment, but I can make it and think, and I do think that moving to looking forward, I think the opportunities that the national planning framework might have to bring that integration in probably do create some opportunities to push that further than we even went in the recommendations, and I think that is quite a positive step and will assist to simplify if we can get clarity on how prioritisation processes and how outcomes are going to be prioritised in different ways, and I would emphasise in different locations, because I think that again is something that we need to be cognizant of. This is a process that that is ultimately borne out in a spatial application. And I think Matt's comments about wetlands and exactly what they are as in an individualistic nature is very important. So going to that question of can it simplify things? Yes, I think it can. Is the legislation doing that at the moment? I think the big emphasis needs to be on getting the plan, moving things back to thinking about that planning process and getting those systems right so that subsequent consenting, the benefits of that subsequent consenting, are looking to how to get that certainty. Just mindful of time, trying to answer that quickly for you, Daniel.
No, I appreciate that. And I think that is all the time we do have. So do just want to say a massive thank you to each of you. A really thought-provoking discussion. And I think coming out of it, there is some real optimism as far as what this reform process has to offer for everyone, and particularly for the infrastructure sector itself. So thank you all for your time. And I think that will be us signing off.
Thank you.
Thank you. Kia ora.
Thank you all very much for your contribution to the discussion this morning. As Daniel mentioned, it's great to see so much audience engagement, but the optimism that that comes through about the opportunity for reform and a fresh start is really great to see. Thank you also to Russell McVeagh, the session sponsor for this discussion this morning. This conference wouldn't be possible without the sponsorship from our members, so thank you for that. And to those of you in the audience, if I could now direct you to the next session, lessons from Scottish water reform with Alan Sutherland, who is the CE of the Water Industry Commission for Scotland. Mā te wai.